we've created Medicaid 5-year look-back trusts for couples. We're less likely to do that because with couples, Medicaid's laws are much more generous than they are for singles. So if you're a couple and you're looking at Medicaid eligibility, you're both alive, Medicaid lets you keep about $65,000 to $135,000, $140,000. Let's say you have too much, you have more than that. Your house doesn't count, your car doesn't count, $135,000 doesn't count, but let's say you've got $100,000 or $200,000 or $300,000 beyond that, which counts. Medicaid allows you to buy what's called a Medicaid compliant annuity. You take, therefore, countable assets, i.e. money, and you make it non-countable by buying an annuity that Medicaid allows. This is done at the time of need, at the time of the Medicaid application. You never buy a Medicaid annuity before you need it. Part of the rules about Medicaid annuities is that the state has to be named the beneficiary of the annuity after the well spouse. So you buy it in the name of the spouse who doesn't need care. That annuity pays back to the spouse during that person's lifetime. Should they die before the end of typically a 5-year term, then the state of Washington gets the next payments. This is not your normal annuity. This is not the type of annuity your financial advisor would talk with you about. Most financial advisors would never sell this annuity unless they're working with an elder law attorney. The point of it is, however, that for couples, the rules about Medicaid eligibility are much more generous than they are for a single person. We have more tools. So we have a way to qualify couples, qualify the ill spouse for Medicaid without spending down their assets, without having to give them away by using, for example, the Medicaid compliant annuity. That's not to say that we haven't created Medicaid 5-year look-back trusts for couples. Absolutely, we have done that. Remember, Medicaid has a 5-year look back. So if the couple is concerned that they want to protect assets, for example, for their family, there's a couple ways they can do that. They can actually just give the assets to their family. If the couple, for example, has that lake cabin they always want to keep in the family, they can give that lake cabin to their children, create an LLC for it, or an irrevocable trust. Any of those mechanisms work for getting that asset out of the ownership of the couple and giving it to somebody else. And if you do it 5 years before the need for Medicaid, before long-term care, Medicaid doesn't care because they only have a 5-year look back. They don't care what you did in the 61st month, for example. Sometimes we've given away, maybe it was a family farm. We gave the family farm and it was in an LLC. We put it in an irrevocable trust for the benefit of the children of the family. You can do all of those things to protect those assets, especially important with legacy property or with farms, etc. That is something that can be done. If it's done 5 years before the need, Medicaid eligibility is not impacted. So 5 years before the need is when you would give this sort of assets away to outright, an LLC, in a trust, irrevocable trust, etc. What I want you to know, and this is not commonly known, especially by estate planning lawyers that don't do, or elder law attorneys that don't do Medicaid applications, is that there are ways to protect your assets, not just giving them away 5 years before the need, but at the time of need. And the primary way to do that, at least for a couple, is through using a Medicaid compliant annuity. I really have to emphasize that because this is not well known. Frankly, it is pretty much a secret unless you're talking to an elder law attorney that does Medicaid applications. So don't think you have to spend all your assets. Don't listen to the neighbor or somebody who said, no, you have to give everything away. Instead, seek out an experienced elder law attorney to help you because you can protect your assets.